All right, good evening. We're live. This is Meet the CPS Defense Experts, and I am attorney Vincent Davis. I'm a licensed attorney in California. This December will be my 35th year as an attorney and about 32 years practicing in this CPS arena. Tonight, our special guest is attorney Andrew Haas. And just as a warning, Andrew and I work together. So he's an expert. That's why I hired him. And so he'll be here answering questions, telling stories. Hey, Andrew, why don't you give yourself, the viewers, a quick bio about yourself? I know about you because we work together, but a lot of people don't know about you. They don't know who Andrew Haas is.
Hi, good evening. Yes, thank you, Mr. Davis. It's a pleasure working with you. I do work with Mr. Davis, and we work on CPS cases. My name's Andrew Haas. I've been an attorney for over 10 years now in the state of California, and I've been working on juvenile matters going back to law school in juvenile delinquency clinics and juvenile dependency clinics. And when I left law school, I started practicing in juvenile courts. And for the last 6 or 7 years, I've been doing primarily juvenile dependency law and dependency cases. I've worked in counties throughout the state of California on these cases and have handled probably thousands of CPS cases now at this point. And I'm currently working on DCFS cases primarily in Los Angeles County, but again, throughout the state of California. And I'm here to represent mostly parents who are fighting for their rights and fighting to get their kids back or keep their kids out of the grasps of the system and DCFS and other child protective services in other counties.
Very good. Where did you go to law school, Andrew?
I went to Loyola Law School in Los Angeles,
Okay.
and where I participated in juvenile clinics. I went up to undergraduate at the University of Michigan in Ann Arbor. I'm originally from Chicago, Illinois, and I've always wanted to be a lawyer growing up, and so this has always been a passion of mine, and particularly fighting for the rights of individuals against government agencies that come in and try to take people's rights and make sure that we're fighting for due process and for representation in court, and so that people can be heard and not just get steamrolled by the government or anyone else.
That's an interesting point. People getting steamrolled in CPS cases. I hear that all the time, and I hear it from not only from lawyers, but I hear it from the parents, and I hear it from parents all over the state of California, all over the country. What do you think is going on that everybody has this opinion about what goes on in a CPS courtroom? What do you think's going on?
Well, there's a lot of things going on, I think. I mean, it's these government agencies are given wide discretion, and they've basically handing over power to social workers who in their minds are experts in every field. And so they write these reports, and the courts rely on them, and departments rely on them, and sometimes attorneys rely on them. And essentially, they're given the authority to make decisions as to what's in the best interest of a child or a family, or what needs to happen. And I think that, obviously there's a lot of issues at play in terms of monetary incentives and funding issues. And these agencies, employ vast numbers of workers, especially in large counties like Los Angeles. But throughout the state, and they also rely on some federal funding. But I think it's really when they're talking about getting steamrolled, they're talking about a social worker who maybe met the children once and maybe met the parents once, and they're writing these long reports and putting forth opinions that don't really have the foundation that is necessary to make those types of decisions. And they're not made in the interest necessarily of the children. I think that what's always overlooked is sort of the impact and the trauma of children being removed from their families. And essentially becomes the department or the county social services agency covering for themselves and making sure that, that they're not, that they're doing what they can to protect themselves from liability and to, but not really do what's in the children's best interests. And so,
there's a viewer, I think, on our YouTube channel. Her name is Zen. It looks like Zenadia Diaz. She says, "Thank you, lawyers, for always sharing with us the best tips that help us on our CPS cases." Andrew, as you sit here today, right now, what's the number one thing you would tell a parent that's involved in a CPS case?
That's a good question. And of course, every case is different. And so, you really do have to look at every case uniquely, but they're all the same. And that is that the social worker is generally going to be using things against you when they can. And, so I think that the best advice is to, consult with an attorney and, and limit, consult with an attorney to see how to navigate these waters. I think that it's too often parents try to do it themselves, and it's a very specific area, and there's very few people who know how to navigate it well. And I think, parents' instincts obviously are to protect their children at all costs. And it's a very emotional time for parents too. But I think that's exactly why you need the assistance of legal counsel and experts in the field to give you objective, advice based on experience working with and against these agencies.
I talk to a lot of people, and as do you. Do you ever come across a client that is hesitant to take your advice because they think they may know better about how to handle a case?
Yeah, I mean, definitely we have come across clients who, have their own view of the facts or a view of the case or a view of the system. And usually it's coming from a protective place. They want to do whatever it takes to protect themselves and protect their children. And, and they're scared and emotions are running high because these are their children at their most precious, possessions, if you want to call them that. But and so they're coming from an emotional place. And so they want to do instinctually what they can. But and certainly, and a lot of times they're just meeting us too. We're coming into their lives in very emotional and times, and they've sometimes have undergone some traumatic experience, or their children have had some traumatic experience, and and you're meeting a stranger, and so it's our job to really make sure that they're comfortable and build a level of trust. But certainly, clients, will often not abide by the legal advice, and sometimes it's hard. The legal advice, it can be difficult to abide by. It's not necessarily what you want to hear all the time, but as lawyers, our job is always to do what's in our client's best interest and to fight for their objectives and what they want to do in court, which is generally get their children back as soon as possible.
Now, let me ask you something. You've been a lawyer for double-digit years. You said 10 years?
Yes,
okay.
A little over 10 years.
And you've been doing juvenile dependency matters for many years. What is the most, egregious case you've seen in terms of how the agency or an agency has acted in a particular case towards your client?
Well, as I stated before, I mean, they get this mentality where they think they can steamroll everyone, and they get an idea in their head of what's true or not true based on just, sometimes it's just speculation. Really, at the end of the day, it's their guess or their belief of what's happening, and and once they start building their case, they're going to do what it takes to sort of manipulate the facts, and because of the rules of evidence in these juvenile proceedings, and are tilted sort of in favor of the department and the social worker, they're able to manipulate evidence and frame a case, how they want to, and a lot of times we'll just outright, at times outright just lie or make things up when it's convenient for them. So, it's those are the types of cases is when, and a lot of times they want to cover themselves too. So they might not have been available for parents and given parents the appropriate information that was necessary for parents to participate in services or do the things the department wanted to, and they just didn't do their job. And I think that a lot of times they don't fully investigate things. And to me, that's always the most egregious, is when there are stones that they didn't turn over, that they that could have helped keep the kids, the family together, and because for whatever reason they've made up in their mind that they're going to put the children in foster care or keep the children from their parents. I think they manipulate facts and massage the evidence in their favor. I'm trying to think of a specific example, but
let me jump here and ask you something, because you mentioned something to me just now that I think is extremely important. As a matter of fact, I did a YouTube video, a short today, about this very topic. You mentioned evidence and the evidentiary rules. Tell me a little bit about evidence, because, I talk to a lot of people and they think they know the law. They've read the law, for example, the Welfare and Institutions Code, or they've read the Constitution, which are laws. But evidence is probably the second most important thing in these cases. And there's so many evidentiary rules about letting in evidence and keeping evidence out. What do you think about evidence and how important it is to these CPS proceedings?
Well, it's vital to these CPS proceedings to understand how they work, and what's going to actually be considered by the judge at the end of the day. People are right. Most people know sort of their basic rights under the Constitution, which are these big laws that protect us. And they may even know some of the other laws like hearsay and things like that. But when it comes to CPS cases and dependency law, in California at least, there are very specific rules of evidence, even more specific than the general rules of California evidence in civil cases and even criminal cases. And that's why it's very important to have an attorney that knows the dependency law system and knows the dependency laws and how they apply. Because at the end of the day, if you don't know what evidence is coming in and what's not coming in, then you're going to have an issue in front of the judge. But it's crucial to every case, because essentially the rules of evidence have allowed or will allow social workers to introduce evidence, including hearsay evidence, including evidence that oftentimes lacks foundation, that lacks, they'll put forth their expert opinions. But most of the evidence they write in their reports is probably going to be considered by the judge. And then what's so unfair about it is that those rules only apply to the social worker, or only apply to DCFS. So that when we try to use, we can't use hearsay, or we can't use, evidence that lacks foundation or that hasn't been approved or certified by the department, then, we hear objections. But the state legislature has decided that these courts can hear evidence and can admit evidence that would be objectionable probably in every other courtroom in the state and maybe the country. But there are very specific rules that broaden what is admissible in juvenile court. It's very important to understand that, not just in court, but also when the social workers are writing the reports and investigating the cases, because they're going to use what's helpful to them at the end of the day, and their lawyers, and they're going to omit things that aren't. And when they omit, and I think that's when they omit things, and going back to, some of the egregious things that go on, to me, that's almost worse, is when they leave out favorable things, because it's hard for the parents or other parties in the case to introduce that same evidence without bringing in, direct witnesses and other people who know of the evidence. So, and that's why it's important to have lawyers who are willing to do that and fight for that in these very busy courtrooms, who don't necessarily want to spend all day on 5 witnesses. But if that's the only way we can get the evidence in, then that's what it takes. And so it's crucial in navigating these cases in and out of court to understand the very specific evidentiary rules that will apply.
All right. So if you're watching this live with us on the different social media platforms, go ahead and post your question in the comments section, and I and Andrew will try to answer those questions. Andrew, many years ago, when I started doing juvenile dependency law, there was a panel that represented all parties except for the social workers in juvenile dependency cases. So if you were on the panel, you would represent parents sometimes you would represent relatives, and sometimes you'd represent the children. There wasn't a separate minors counsel's law firm. So when I was on the panel, but way back when, I used to represent kids and parents and relatives. And it gave me a very unique, view of this whole process. Today, I find, don't get me wrong, I think there are a lot of good minors attorneys. But sometimes I get the feeling that, the minors attorneys are more concerned with sometimes liability, more concerned with, doing what the social worker wants to do. And, I get uncomfortable a lot of times because I get the feeling, nobody's ever said this to me, but I get the feeling that family reunification services isn't the number one priority. Do you ever have those types of feelings, like you kind of scratch your head and think, what's going on here? What's the minors attorney talking about?
All the time, yes. It's and that's the most concerning thing, is when we understand the department is it's a government agency, and they're going to come in and protect themselves, essentially. But when you have a minors attorney who's been assigned to represent a child in juvenile dependency court, who has an ethical obligation to do what's in their client's best interest, and depending on the age, do what their client wants them to do, most importantly. And they don't always do that. I think that they do. It's almost, you get a lot of minors attorneys whose imaginations run wild, and they go off of sort of the worst case scenario. And that's not the standard in juvenile court. Of course, bad things can happen. And, I had a judge in a training once say, you do this long enough and you'll see bad things will happen with parents, and bad things will happen in foster homes. So you really have to, do what's right in every case. And, for them, that means developing a relationship with their client. I know that can be more difficult with younger children, but a lot of times they don't have the time, or they don't have, the concern to actually connect with their client, to meet their client, to go out and see what's going on. And it becomes, they don't want, they want to just cover themselves. They want to make sure that they're firm, or that they're not liable if anything were to happen, and not, not giving the due weight to the harm that they're causing these children who are away from home. And they're not committed to the reunification effort, which is, again, in most cases, the duty of both the department, the court, and the attorneys to engage in that process and to make sure that that's what everyone's working towards even. And so when you get them not even working towards that, but sort of like a keep away or, then it's, I think it hurts the children most importantly, and it's not fair to the parents, and it's depriving them of their rights. And it's one of the most frustrating things to see a minor's attorney interfere sometimes with that reunification, where everyone's I've had cases where everyone's on board, and the children's attorneys, for return or reunification, and it's the children's attorney who's sort of putting forth their own view without necessarily even their client's consent or wish, and sometimes against their client's wish. So that can be the most frustrating thing. And then you get courts who are taking them at their word that they're representing what's best for their clients, when oftentimes they don't know or they don't care. And I think it's very frustrating.
I will say that the hardest party to represent in a juvenile case is the minor. And the minor's attorneys have so much responsibility. They got to keep the kids safe, but they have to support reunification services, right? They want to keep the kid in a good, balanced home, like a foster home, but there's also relatives to consider. When I was on the panel, one of the reasons why I kind of hid when they were looking for attorneys for minors is because the judge in whose courtroom I was in made the minor's attorney do a lot of work. Like, you couldn't come to court and do a case unless you could tell the judge, yeah, I talked to the kid 2 days ago or 3 days ago or within the last week. He made sure that you talked to your client. And he expected you to make a report to him about how the kid was doing, if the kid needed anything. And I always thought, well, why doesn't the social worker do that? That's what I thought. But he expected it from the minors counsel, and he put a lot of responsibility on the minors counsel. So I know that these people that are representing children right now, they have a lot of responsibility, and it's very difficult. They got to be fair, but they got to be protective. And sometimes in cases, it's hard to be both, right? It's hard enough, the judge got to do that, but now you got to, the minor's attorney's got to do that. And one of the things that I see a lot, and I see this all over the state of California, is really good minors attorneys. They get hired by county council to go represent social workers, right?
Absolutely.
So, you lose a lot of, I guess, really good attorneys to them representing the dark side, the social worker side. But, that's just a matter of economics, because the social workers' attorneys I think they're the highest paid in the system, right? So they make the most money, have the best benefits. So where are those attorneys going to go?
Right, they are sort of at the top of the food chain, and you do see that often. Is the good children's attorneys will move up, to county council, and it's a little bit, like you said, better benefits, better, it's generally the top of the food chain there. But and I understand. I've represented minors as well in delinquency and in dependency cases. I was on a panel for some time as well. And it was mostly parents, but from time to time, I would be appointed for a minor, and it's a lot of responsibility. And at times, these are children; you can't rely on them to make decisions or even understand the decisions that they're making. And so, you have to interject your own opinion. Sometimes, whether that's consistent with their wishes or not, or maybe they're just a baby or they're young and they don't have an opinion or don't understand the proceedings. And I can understand that, and it is a lot of responsibility. But that's why they're appointed, and they do make this. They're there to help reunification, help get the kids home. I think, and that judge that you worked with, that's a perfect example. They should have the most information, and they should be on top of the case the most. There's nothing more frustrating than coming to court on a review hearing and everyone's ready to close the case, and minors counsel says, well, no, I got to go visit the kid. I haven't seen the kid. Well, I didn't know that it was going to close today. Well, we're here for a review hearing. You should be ready for the case. The case should be closing. That should be the norm, is the case closing. And so you should be prepared for that. There's nothing more frustrating than waiting 2 more weeks or a month or more, depending on the court's calendar, to come back and have the case closed just because they didn't talk to their client. So,
right. I don't know if you remember where I first met you. We won't mention the county. It wasn't Los Angeles County. But many years ago, I was on a case in that county, and it was there for like a 6-month review hearing. And the recommendation was to close the case, to JT the case. And minors counsel asked me would I agree to a continuance. And, I thought, are you kidding? And that's what I'm thinking. Like, why would I agree to a continuance so that you can go call the minor? Because I'm coming from the old school. You should have called the minor before you showed up to court.
Right.
I didn't agree to it. And, the judge didn't say anything, but gave me a look with, the raised eyebrow. Like, why are you jamming up the minor's attorney? And the minor's attorney was honest. He said, look, I gotta go check on my clients. I haven't been able to do that, blah, blah, blah. So now it's almost like it's, just a matter of course. Oh, minors counsel said he didn't get to talk to the kid. I guess we got to continue it.
Right.
But,
no, it's unfortunate, and it's a reality in some counties and some courts. I mean, I understand a lot of the appointed attorneys are overburdened with caseloads, and the courts are overburdened. But it almost becomes, I think in some of these counties, it almost becomes a tactic, I think, for minors attorneys to rely on that continuance. Sometimes, maybe that's just, a little cynical, but that's, it seems like that sometimes in certain firms. I mean, there are policies in different minors attorney firms, and I think I wouldn't put it past them to use that sort of almost as a tactic to keep cases open, to cover themselves, if because you never know, that can happen in a month. You never really know.
One of the things that I have come to, I guess, learn and sort of appreciate is, everybody doesn't have the same beliefs that I have. And I know I'm not always right. And I'm always trying to listen to other people's opinions. And, I have a different background than a lot of the attorneys that we work with in this system. That doesn't make my background perfect. It's not perfect, let me tell you that. But, a lot of people have different ideas, different feelings about certain things. And so I've come to appreciate those in terms of minors counsel and hearing them out and listening to them. There was a time, a couple decades ago, I didn't even want to hear what the minors counsel had to say. It was almost like irrelevant to me. Like,
right.
You would try to do something in court, and county counsel would always ask me, well, did you run this by the minors counsel? No. Like, why would I do that? Well, Mr. Davis, they are a party in the case, right? Judge is going to ask them, hey, minors counsel, are you going to, what do you think of this, right? So I've come to appreciate that and seek the input of some of these attorneys. I don't always agree with them. More times than not, I don't agree with them. But there are some times I do agree with them, and I think to myself, oh, yeah, this is something that we have to address, we have to consider. And, I try to look at cases from different points of view. I'm a graduate of something called the Jerry Spence Trial Lawyers College. And Jerry used to always say, you got to look at the case from the perspective of the other people in the case. Your perspective doesn't mean, SHIT. You got to consider what other people are thinking and feeling about the case, especially the judge, right? Because he or she is making the decision, not you. You know.
Absolutely.
Um,
Yeah, and I agree with that. I mean, you do, uh, sometimes you just know that they're not going to agree with you or see eye to eye with you on a certain issue. But sometimes, you can even get them on your side, and if you have them on your side, that can go a long way. So it is it is definitely worth it to. And again, these are very, we're in front of the same judges in the same counties, and it's a lot of the same people. And I think most minors attorneys are there for the right reasons. And so you try to work with them and see eye to eye, and come up with a plan with them if maybe they do have legitimate concerns, and so that you can address them.
yeah.
And it is about relationships and building those as well. So that can certainly be useful. And you never know, sometimes you get them on your side, and that helps a lot.
Hey, Andrew, here's a question right now. It's from Jennifer. Jennifer says, my rights have been terminated for my youngest son. I appealed it and it got denied. Now they are trying to adopt my son to the foster parents. Can I get my rights back? And can't my family adopt him? So, Andrew, I want you to assume that this nice lady, Jennifer, is from California, okay? Because we're licensed in California. If she is from California, how would you answer those two questions?
Well, first I would, I'm sorry that it sounds like you've been through the process, and if you say your rights have been terminated, I think the first avenue is the appeal, which it sounds like you've tried, and to review that. If the appeal doesn't work, then they're very limited, if no circumstances under which you could probably get your rights returned to you. It is a final decision, although when the children turn 18, they're adults and you could resume a relationship. In terms of the second question, your family, if they have not been adopted, yes, your family can still come forward and try to adopt your child. And they can come forward. They would have to speak with the social worker. They could hire an attorney to help them navigate the process. And it depends on a number of factors. Obviously, every case has a different set of very specific facts, but they could still come forward with the department and try to, particularly if they have a strong relationship with the child, try to adopt them, or try to have have the child placed with them, and try to explore a number of different permanent plans to have the child in their life. And so before the child is actually adopted, then they could still petition the court and petition the department to evaluate them. And there is a number of factors that the courts can still consider with the permanent plan for the child, including what kind of relationship they have with relatives, and even the legislature has in it provided that a presumption that relatives should be prioritized over foster parents or strangers. It's even the state legislature has recognized that there is a benefit, just all else equal, there's a benefit to having and maintaining a relationship with your blood relatives and family members, and even friends in some cases, non-related extended family members, and to have that connection with your family, because that can be an important piece for a child growing up, and not having that can impact them negatively. So your family still can come forward. Outside the appeal, I think, if you could try to take it up to a higher court, but so I don't think you could get back to court and reverse the termination of your rights. But you could still have your family come forward and try to intervene.
All right, Andrew, here's a question from Virginia. Is there any way I can have the GAL see my side and everything I've then am doing? Can I contact her? Now, Andrew, I don't know if you know this, but in a lot of states, the Minors Council is called the GAL. All right. And in California, it's different. We have Minors Council, and there is a GAL in some cases, but in a lot of states, the GAL is the minors attorney. So let's assume we're in California. Virginia's case is in California. What do you tell Virginia about that question about her contacting the minors attorney?
Well, in California, there's certain ethical duties that that lawyer, if it is minors attorney, that you wouldn't want to contact, and for a number, and strategically, you wouldn't want to contact them directly, but also they probably wouldn't be able to communicate with you directly if you're represented by an attorney in court, and they're representing the minor. There's certain ethical considerations. Attorneys can't communicate directly with the parties in a case, so they would have to go through counsel. And I think it's to your benefit to make those communications through counsel as well, so that they're presenting your case in the light most favorable to you. And so I think that the best way to go about doing that is to provide this information. It's the things that you're doing and the things and the progress that you're making, and services you're participating in, or whatever side that you want them to see. I think it would be best served going through an attorney. And sometimes I know it feels, especially with appointed counsel, hard to be heard with them. But I think that would be the best route, is to present everything and have your attorney present it to them strategically. And they might, again, have a relationship with this GAL and know what they want to see, and they can have a more frank conversation. Actually have a conversation. Like I said, I don't think minors attorney could engage you in a conversation. So
I agree. It's a dangerous strategy for you to contact any attorney other than your own attorney. And here's something that happens a lot. Sometimes, and I'm going to assume you're a parent and that you're a very smart individual. You think that the minor's attorney is just going to listen and do what you believe is reasonable and fair. And that's not the case all the time. Sometimes the minor's attorney has a different stake or a different look at the case than you do. All right. And that may be because you know more information about the case, or the minor's attorney may know more about the case. Remember, the minor's attorney, they usually have investigators and social workers, and they have complete access to your child. So they could have, talked to your child, and the child could have said something that you never would have dreamed of the child saying. So it's not a good idea. And if you talk to a minor's attorney, be aware that minor's attorney will use your statements and comments against you. And there is a possibility that the minor's attorney may either mistakenly or intentionally misquote you. And then where are you? It's like, the police come knocking at your door. Hey, did you rob the bank yesterday? Well, you've been watching movies and TV shows. What are you supposed to say? I have to talk to my lawyer before I can talk to you. The same is true with these types of cases, in my humble opinion. Don't talk to social workers without your lawyer. You don't know what you're saying and what can be misconstrued. Just the benefit of having a witness there to make sure that the social worker doesn't misquote you is worth, the weight in gold by itself. Hey, Andrew, here's another question from Laura. Laura Sanchez says, "Good evening. I have a question for you. The foster parent that has my girls has a criminal record. The foster parent herself got the girls taken away from her. I bring it up to the social worker, and she threatened my husband and me by separating my two girls and as to jail." Didn't understand that. What else can I do? So I guess the kids were with a foster parent. Laura turned them in, or whistle blew that they had a criminal record, and now the social worker has put the kids in two different foster homes. Assuming Laura's in California, Andrew, what do you tell her?
Well, I mean, again, I would first ask, how did you obtain, evidence that this foster parent has a criminal record? And I would, look into what that criminal record was, um, just to make sure that was, that we were sure about that. Um, if you think that, at the end of the day, if you think your child's in danger, you can always, call the hotline or make a referral. But generally, they foster parents go through a fairly strict process of live scans and other background checks to ensure that they don't have these types of criminal records. But sometimes there's information where people are living in the home that they may not know about, or that or for some reason they've overlooked. There's also certain instances where a criminal record can be exempted. So I would want to know what the criminal record was and where that information was obtained. And again, go through your attorney to present it to the court, to present it to the department. A lot of times they take everything that you say with a grain of salt, because they think that you're going to say or do whatever it takes to get your children back. And so they may think, they may not believe you. And again, there's always a risk of them using it against you, or you saying something that might not benefit your case. And they're going to say that you're not focused on your case plan, or you're not focused on this, and you're only focused on this issue. And it doesn't always, I think a lot of parents think that if they can get the children removed from the foster parents, that means the kids are coming home. And that's not always the case. Unfortunately, it just means another foster home. Now, that doesn't mean if there are legitimate concerns, then, you should first report it to the social worker, which you did. Then I would speak with your lawyer. I would speak with your lawyer first, and then, but you can report your concerns to the social worker, legitimate concerns. And if there's a real, immediate risk or something like that, you can make a referral, or even obviously call 911 if there's an immediate risk or harm to the children. But again, I think in all these cases, it's important to consult with your lawyer to find out what information they have. And if you need to present information to the department or to the court, to do that through your attorney. But those are difficult situations, because again, the department is given wide latitude to approve or not approve these foster parents. And
here is another question. I guess it's a follow-up by Laura. I did all that and nothing has been done. I took the foster parent's record and took it to the social worker, and she read it and then ripped it up. Now, Laura, there is something that you can do. And I hope you're listening and you have a pen and a piece of paper. You can file complaints against the social worker and against this entire process in 3 places, and I urge you to do it. Number 1, you can file a complaint with the Department of Health and Human Services in Washington, D.C. They control all money that is given to these states for CPS cases, and they do investigations, and they do take action. The second place you can file a complaint is the United States Department of Justice, the Civil Rights Division. And most offices now have a specific CPS subdivision where, because they're getting so many complaints about citizens and even non-citizens, residents of this country, their civil rights being violated. And, the government and the Justice Department has the responsibility to investigate those things. The other thing and since you're in LA County, the other thing that you can do is you can file a complaint with the Department of Social Services in Sacramento. They control all social workers, or they have supervisory powers over all social workers in the state of California. What you also might want to do, but probably nothing is going to happen, is you might file a complaint with Los Angeles County itself to investigate its own social workers. I've seen it be effective in some occasions, But for the most part, in my humble opinion, it's like asking the fox to watch the chicken coop. So try all three or try all four, and come back in a couple weeks on the show and tell us what happened. Okay, Andrew, here's a question from Kelly. Kelly says they removed my children without a court order, without a judge's signature, by threatening and coercing me into signing a, quote, voluntary, unquote, agreement that I tried to revoke at one point because the placement was disrupted due to no fault of mine or my kids, so I wanted to get my children back. And the caseworker told me I was not able to do so. And she went and picked up my children before having a court order or judge's signature. They have no evidence. Okay, Kelly, well, first of all, Andrew, what do you think about that?
Well, I think it's unfortunate when they come to your home and they threaten you. And I think the scariest thing for anyone is to have their children removed from them. And so they do tell you, oh, this is, do this, do that. This is, we're just going to go get a warrant. We're going to get the cops. We're going to come, take them away from you. And then, they say it's a voluntary agreement, which, is relative. I understand that there's a lot of pressure and duress in these situations. And, legally, I think that, the term voluntary would be of your own volition. If there wasn't, clear threat of violence or something like of that sort, the courts would probably accept it as a voluntary agreement. I mean, I think that if you knowingly signed away temporary custody, that the courts might uphold that. But I think what you have to do is you have to go to court and you have to have your attorney present evidence as to why there's not a current risk. And, again, not to trust the department. They will tell you everything that will benefit them. And so, if they have no evidence, I think that you need to consult with an attorney and go to court. You are entitled to have a hearing within 2 days. I think some of that's been extended with the COVID guidelines. Some of those statutory dates have been extended a little bit, but you do have a right to come to be in court within a matter of days, and to be heard as to what evidence they have regarding the removal. And if they did lie to you, and if they did threaten you, I think that's certainly relevant to whether that is voluntary or not. It's always, that's why, I think we say this all the time, is you need to talk to your lawyer before you sign things and have them reviewed. And it's hard when you're under that kind of pressure. And sometimes they come in the middle of the night, or they come, at a time that's not convenient, or it's hard to reach out to a lawyer. But it's vitally important not to sign things without knowing what you're signing or understanding the consequences of them. But I think ultimately you will get your day in court within a matter of days. And, that is one way they manipulate parents, is to sign them over. On the other hand, I don't know the evidence, but, if you don't sign, they might apply for a warrant, and depending on the circumstances, you could have a scene with the police officers at your door and serving a warrant to remove your kids. And that can be, traumatic for everyone as well. So, but it's important to know what you're signing and to, if you can, consult with an attorney so that you know what you're doing it, why you're doing it, and you can make a conscious decision. But those are tough situations That's another way that the department again steamrolls you by saying, just sign this, everything will be okay. And police officers do it all the time in criminal cases. Can I come in? And then that seems like sort of an innocent question, and then they they're looking around and they're over, and you said I could come in, and they go to court and they'll tell the judge, they said I could come in, and that's consent, and that's signing this document is voluntary if you did indeed sign it without some threat of force or or something other totally improper other than them going to get a court order.
Here's Kelly with a follow-up. She said they did call the cops when we asked her to get a judge's signature, and the officer was right there with her, threatening me with foster care. We have been fighting this since March 30th, 2021. They subpoenaed someone to court to testify who lied under oath, and we have solid evidence proving that they lied. Hey, Kelly, what I want you to do, because I had a case very similar to this where I represented a mother and 2 children in a civil rights lawsuit against a county and some social workers. Tomorrow, give me a call because I'd like to talk to you more in detail about it. Call me at the number that's listed there on the screen, 888-888-6582, 888-888-6582. And I will get some more information from you and see if I can assist you. Andrew, any big trials coming up?
Yes, there's always some trials on the horizon. I have a few coming up in the next few weeks. Some adjudications, meaning some initial trials on the petitions, and also some trials as to review hearings and things of that sort. I've got a big trial coming up. It's actually an interesting case. The case has been going on for a little over a year. Parents were doing everything they could do. The child was returned to the parents. The parents were working on a custody order to close the case. And as they were working out the custody order, the department filed a new petition alleging misconduct against the father. And interestingly enough, the initial case came to DCFS because the mother was saying things that were not true about the father to the child, and having the child say those things. And so it's kind of like another instance where this happens right at the bell as the case is closing, and they seem to be working out of some sort of shared custody. And these can be some of the toughest cases. These cases that are really family law cases. They get tied up and tangled up in juvenile court. But they made a very serious allegation against the father, and that trial's coming up. I think the allegation would have criminal implications, but law enforcement has investigated and ruled out anything because they seriously doubt the credibility of the evidence that's being put forth, and it's going to be an interesting trial. So I'm preparing for that, and have a number of other trials coming up, and detention hearings, and there's always contested hearings throughout these cases. So
let me ask you this. We have about 6 more minutes in the show. I'm going to give you a hypothetical, and then I want you to tell me how you would advise me if I was, really your client. I'm a father, I'm married, and I have a couple of kids. All right. One night, me and the wife, we got into an argument about, she thought I was cheating on her. All right. She hit me and broke a plate over my head. and the kids called the police. The police roll onto the scene. Um, I'm a little bit drunk. It was the weekend, and I get arrested for domestic violence. And the social worker, to make matters worse, they call CPS, and they file a case against me. They file a case against me for domestic violence, for substance abuse because I was drunk on a Saturday night, and they also interviewed my kids. That I couldn't figure this out, but they wanted to know what I did as far as disciplining the kids. And the kids said that I whipped them with a belt, which is true. I got whipped with a belt when I was growing up, and thank God I did. But that's how I disciplined my kids. So now they're telling me I have to be in court on Monday morning. They've made me move from the house. Okay, the kids are still with the mom at the house, and they've made me move. So I got arrested. Now I have this juvenile case, and now they're telling my wife that if she doesn't divorce me, okay, they're going to take the kids from her. So she went out and got a divorce lawyer, and they filed a divorce against me. So now I got 3 cases going on from an incident that wasn't really my fault. What should I do?
Well, I think that that's unfortunate, and I hope that you're okay with the plate. I hope your head healed well. But I think you need, you're now facing 3 very serious cases that could impact you and your children's lives and your entire family's lives for the rest of your life and your children's life, and one night sort of can changed everything. So I think the most important thing is to, obviously you're going to need legal counsel, and you need to consult an attorney to help navigate these systems. The dependency system is going to determine, at least initially, what happens with the children. And so that, that case is probably going to happen quicker and take priority over the family law matter, and have jurisdiction over at least the custody orders in the family law matter, and will probably happen much quicker than the criminal matter would. So it's important to understand that system. Initially that will, and of course that will set the tone for the other cases, and how you fare in juvenile dependency court will in large part determine how you fare in family law court and to some degree in criminal court. It's good to have an attorney who understands how the different systems intersect and how they don't. But it's a difficult situation. I mean, there's, in the criminal case, you have Fifth Amendment rights to remain silent. And then in the juvenile dependency case, you're going to want, your instinct will probably be to fight for your kids and try to explain things away. And so it's you can't underestimate the importance of having a lawyer, someone who knows the systems and knows how to win in the systems, help you navigate that. I think that's too much for any person without the legal knowledge and expertise to know what to do. And there's not always even a right legal answer necessarily, but you need to understand how each case will impact the other, and which one will take priority, and and what's at stake, really, because the criminal matter, depending on what they're charging you with, can leave you in prison for years, or but the dependency case will determine where your children are and where they aren't. But seeing that your wife or wasn't shy about getting an attorney, filing for divorce, and positioning herself to prevail and to use the legal system to her benefit. You can't be shy about that either. I think that your instinct might be to try to get everyone back together and go back to how it was, but it's going to take time, and it's going to take legal expertise in order to do that, and still stay out of prison and stay out of jail, or avoid a conviction, and get your kids back. I think that these are all too common stories that happen. The last thing you want to do is try to navigate them all on your own. In dependency court, the appointed attorneys aren't going to address the other issues. They're going to be there for the very specific dependency case. They may not know or care about the criminal case or about the family law case, because they've got too much else to worry about, or they may just not know. They may only know dependency. But understanding the different rights and different consequences of each system is of utmost importance, and I think beyond most people's common understanding. So you need experts to help you.
Very good. Well, Andrew, we've reached the end of the show. Time goes by goes by fast when you're having fun, right?
Absolutely.
Everyone, I want to introduce you again to an expert in this area of law, Attorney Andrew Haas. Andrew and I work together, so if you want to try to get in touch with him, or if you have further questions, you can reach him at 888-888-6582. Thank you again, Andrew, and we'll have you on back on the show in the future.
Thank you very much, Mr. Davis. It was my pleasure, and good luck to everyone, and take care.
All right. Thank you, everyone. Don't forget, we have our show on Tuesday nights, where I co-host a show with Aaron Carranza. It's called CPS, Family Reunification, Coaching, and Motivation. So it's tomorrow at 7 on these same social media websites. So we'll see you tomorrow night at 7 p.m. Good night, everyone.